what I term as the lead investigator in the case. He was involved in a variety of significant events in this case, both initially and later on, including being present for witness interviews, collection of evidence, assessment of evidence. From my reading of the, I think now about 260 pages of state police reports, I believe that he signed off on a number of other reports, which means he was supervising other members of the Mass State Police investigation team that was assigned to investigate this case. He's an integral part. He was just, for lack of a better word, he was the major player at the outset of this particular case. As for Moore, I will basically say that my reading of the reports in the grand jury, it looks to me like Moore was, his tasks were limited to, and I might be missing something, but I think his tasks were limited to going out and collecting surveillance tapes from private individuals that might have recorded particular events, as well as places like Stop and Shop, Home Depot. I'm forgetting some of the others, but I think he is referenced, I believe he is referenced and he's also making decisions about what to collect, what not to collect. And as for, and I'm trying to find my reference. Yes, he's referred to specifically, and when I say that, he either he's authored close to 22 reports, or he's referenced in 22 reports during the early days of the investigation of the case. I'm going to mispronounce his name because I've done it so many times, but DeChico? DeChico. Well, I got close. DeChico is, he's right below Proctor when it comes to his involvement. He is referenced in at least 43 of the Mass State Police reports. He was at the, interviewing critical witnesses, tracking down witnesses, conducting searches. So he is right below Proctor, and he is signing off. The way I interpret a lot of the Mass State Police reports we've received and the grand jury testimony, he is signing off, so to speak, on a lot of the reports that are being submitted. That's the way I interpret it. So he's a very integral part of this investigation. And I will just, so I think that if you want me to go on, I don't really have much more to offer other than that summary.
Well, then we have two others.
That's Tully and
Buchanan.
Tully was supervising and appears multiple times throughout the investigation. And he signs off as the supervisor, and I don't have the count in front of me, on a variety of the Mass State Police reports as they go through the process of, I don't exactly know what the process is. When I've cross-examined troopers on this, it's that there's an internal, of course, review process where the
roles in the investigation?
Minor, Your Honor. I don't believe that Sergeant Buchanan was present for interviews of the defendant. He was present for interviews of the defendant's mother. And he was present at the defendant's home at one point in time. I do know that that occurred. Detective DeChico, or Trooper DeChico, was the first responding trooper from that unit on the 5th and was present for interviews of the defendant, I believe, for interviews 2, 3, and 4. There were 4 total interviews. The first one, I believe, was conducted by Cohasset PD Sergeant Harrison Schmidt.
Harrison Schmidt?
Harrison Schmidt.
Okay.
And I agree with the assessment of Moore and Kukowski that they were present for evidence collection. Moore was tasked with collecting videos from different stores. Kukowski was present for some evidence collection as well as searches. And I should say DeChico was also present for searches conducted by, and when I say searches,
the investigators during the investigation, and was reminded that he learned about the disparaging comments and remarks by Proctor, and that he knew about them before any protective order. And the reason I bring that up is because the Commonwealth now has stood up and they've said this before, they're not going to call Proctor. The point is that the defendant has a right to show that the investigation has flaws in it. And what we're hearing from the government is they don't want to call Proctor, the case officer. It's not because he didn't do important things. It's because Proctor, along with the other troopers he worked with, seemed to be engaged, at least in the Reed case, but they're engaged in this type of professional misconduct that they got investigated for. And so they're
But
all...
Attorney Tipton, isn't that the case not all the time? But the Commonwealth is often called upon to figure out how they're going to best present their case. And in the regular course, if they can do the job with X witness instead of Y witness, they can choose to do that. And it is the case, in my experience, that law enforcement officers that perhaps have findings against them that are not favorable to their credibility, that they would choose to use another witness. And the rules allow them to do so.
I don't disagree with any of that. But this case And while he was investigating our client, Mr. Walsh, he basically is under the microscope of his own supervisors who are also under the microscope. And so I want to limit it to, we think there is a sound basis for asking for internal affairs reports as we've done because of the close proximity and the fact between the two cases and the fact that a lot of the actors in the Reed case were in our case. And when you see what occurred, in the Reed case and you see the reaction from the Commonwealth, there can be no doubt of the importance and significance of that evidence when it comes to impeaching either that witness or the Commonwealth's case. And so I don't want to say, and I don't take the position, that in any case Proctor worked on, that someone should be entitled to his internal affairs reports. I think we should be entitled to his internal affairs report, given the close proximity and the ongoing investigation that shows that Proctor, as well as some of his supervisors and perhaps some of his other colleagues, were under investigation at the time they were targeting or eventually targeted Mr. Walsh.
All right. Do you want to add anything more?
He's not going to be called in the Reed case, Proctor isn't, that supervisors are being investigated, that there is bias in the record of the Reed case. There might be bias in what we are able to discern when we are able to assimilate the thousands of pages of discovery and reports in this case. So I think this case and in this case stand apart from, for lack of a better word, the routine prosecution and investigation of a case. And the effects of what the state police did, certain state police officers did, and is in the public domain right now, but also some of is captured in the internal affairs reports. I think it indicates something about the integrity and the bias and the way that the Mass State Police approach, at least some Mass State Police officers, approach the way they investigate. And so that's why we think it's important and it's evidence that needs to be placed in the proper form before the trier of fact.
So there are 14 categories that you asked for. On pages 2 to 4 of your pleading. And I want you to walk me through, I guess all but the ones that the Commonwealth, the first two, and answer for me what specific information in the requested records 3 through 14 do you reasonably believe is relevant and material to this case?
Thank you. when they talk to people, when they write a report, and when they choose what to investigate, what not to investigate. All of that goes to how they are thinking about what they think is important. But of course, if they're thinking something is important because they are biased in the first instance against a defendant, like Proctor made clear he was with regards to Reed, that it affects the integrity of what it is they looked at, chose not to look at, and then where they, as the saying often goes, what evidence they followed to get to a result. And
what evidence do you have of any such bias in this case? Any such targeting in this case?
I don't have any blatant words that came out of text messages.
Well, even reasonable inferences. What is it that you're saying? I mean, it seems to me what you're saying is that by virtue of the misconduct that's been publicly reported or you've received in discovery on the Reed case, that alone stands as a basis for the MSP targeting every defendant? What is it about this fellow?
Well, let me...
What information do you have in this case that is any indicia that there was such a bias?
Because I'm trying to be careful here, Judge, because of...
Providing me with some information that's specific to this case. I don't have it. That's why I asked you earlier on, is it your position that any case that Attorney Proctor works on as a lead case agent, that entitles you, or is there something more here?
Respectfully, Judge, I've said no.
I didn't say that he's the lead case agent on.
Well, I'm still going to say no. I'm limiting our request to what we've asked for. But secondly, if the court is inviting us to file something under a strict, not just a protective order, but file it ex parte.
I'm not inviting anything. I'm just telling you what I see the law is with regard to your obligation and whether you've met it out. That's my job today, right? Or not today. Maybe it's over a little broader period of time than that. But I look at what the law says you're required to prove to get to this information. And and rather than say to you, frankly, I want to see further briefing on this, I thought I can handle this in oral argument.
Well,
because I don't want it. I mean, I don't want to. I use oral argument to gather information. I can read the pleadings. I can read the law. The purpose of oral argument is to find out what I don't know, what I didn't see in there, and answer the questions. That's why you're here.
Well, first, I don't think that's what Wayne necessarily says, but
Well,
the court.
I read to you. Do you want to read it together?
Well, I think what I'm saying is the court is setting a burden that's so high. As I've said that many times.
Okay.
Two, Proctor and some of his colleagues have already specifically shown they are biased against defendants. To make an argument that they were only ever biased against Karen Reed is not logical. It's just not logical. And so I think that.
So are they biased is your argument they're biased as to all defendants?
I'm saying they're biased.
That they ultimately become a target of their investigation?
They're biased against Mr. Walsh, especially in the close proximity of the time when they were making.
And so then I come back to where we were when we started this diversion, which is what is the evidence that's specific to Mr. Walsh?
And the third point I'll make is that we can't, and I will not, divulge what we believe is attorney work product at this stage of the proceedings. And the way that we're assessing what the discovery, and we already said we know there's thousands of pages of it, but the point is we're assessing what apparently looks like a failure to adequately investigate critical witnesses or critical people in the case. That basically people are asked some questions, they're interviewed, some of them get lawyers, and then that's the end of it.
So without invading the attorney-client privilege, that process of gathering certain information and then not following up on it, it could be evident from the documents, and I suspect is evident. I don't have the discovery. I haven't gotten into it. The only discovery I've seen is what you've alerted me to. But it could be evident, and the argument could be made, perhaps, I don't know, again, I don't have the documents, from the discovery that's been presented. Let me give you an example, and this is coming completely that I have a job here to do, and that job is dictated by what that language in Wayne says. And I don't know how you met out your burden, and I do think it's clear it's your burden for what you've requested without you giving me additional information with regard to the specifics. It is not convincing to me. Asking me to do is take the fact that Trooper Proctor was the lead investigator in this case. He was supervised by the same group of people that he was supervised for at the time that he was involved in the Karen Reed case, and thus this is discoverable. I think you need more. I don't know if it's out there, frankly. It may be.
I don't know if it's out there, specifics are out there either, Judge, but I do think that the inferences that Proctor was biased against defendants is one of the most clearly established facts from the Reed case that has been made. And I won't repeat what I said a minute ago, and then you have Tully during an internal investigation of Proctor's misconduct trying to hide behind a protective order, and it's pointed out. In other words, there is a bias that is operating in the Mass State Police, at least with these particular actors, that affect the opinion, affect the way they approach an investigation of Mr. Walsh.
Walk me through that again, because you mentioned that, and I'm glad you mentioned it again, because I wanted to go back and get that in my head. So walk me through that again, timing-wise, with regard to when the knowledge of the inappropriate text messages is known to Tully, and how that interacts with, I think it's the May 6th or May 10th date with regard to the evaluation, and also with regard to when he says, oh, I couldn't say anything about that because it was protected by the federal protective order.
I believe, and if the court will give me just a minute.
Sure.
I'm looking for the
Of 80 different judges, and you're going to have 80 different opinions on what's important to them.
Well, I keep reading these paragraphs, and the one that I'm looking for doesn't jump out at me.
So I see that in your request number 9, and I don't want to lose track of the fact that I do want you to go back and address my question regarding categories. But I see that
Can you find it? It's in
number 9, I know that the Commonwealth objected to that. I wrote my notes overbroad, and it should be limited only to the 5-10-24 evaluation of Trooper Proctor that was the subject of the internal affairs investigation of Detective Lieutenant Tully. So is it that so the timeline is there's this 5-10-24 evaluation in which there's no mention of the conduct that was then known, correct? The conduct of Trooper Proctor that was then known, that then becomes the subject of a sustained finding of misconduct against Trooper Tully, right?
Okay, yes.
The
reason I'm hesitating is because when you use that date, for some reason the date isn't clicking for me, so I'm hesitant to say.
Do I have it wrong, Commonwealth? I'm reading, so I know that the Commonwealth objected to that particular one because they said only the 5-10-24 evaluation of Trooper Proctor was the subject of the internal affairs investigation of Detective Lieutenant Tully. and I'm presuming, although I don't know the facts as well as you all know, that as of that evaluation, it was known to the to Tully that Trooper Proctor had shared the All right, I'm there.
So paragraph 30, which is the second to last one on the page, Trooper Tully explained that he first learned about the inappropriate communications that were part of a group text message thread. It goes on to say February 1st, 2024.
Okay.
And then on the next page, Your Honor,
The Federal Protective Order.
that's what I'm getting to.
Okay, good.
That is, if you look at paragraph 30,
We knew then.
yes. So at that point in time, Your Honor, you're dealing with this 1 month window of it's disclosed to Detective Lieutenant Tully on February 1. He signs the disclosure agreement in March 7th, and the EES report is signed off in May.
That's the May the 10th date,
Yes, Your Honor.
and no mention of it in there.
There's no mention in the EES report of the text messages that I know of. I haven't seen the EES report, but reading this internal affairs document,
Report.
it appears that it isn't there.
Okay, let me just, give me a second to make a note.
Believe they knew they were under federal investigation, so to speak, for the way they conducted the investigation in the Reed case. And
So when does that start?
when does what start?
So this is really being investigated the tail end of December 31st, 2022 into the first week of January, first couple weeks of January 23, right?
Right.
So when did the Trooper Proctor and the others come to understand that they were under federal investigation?
That I can't tell you when they became when they.
No, but you said that when they were conducting this investigation, they were aware that they were under federal investigation.
Well, maybe I overspoke on that, but the point is that
Because my experience is they don't tell you that you're under investigation until they tell you you're under investigation when you're told you're a target.
Well, I think that there were, well, I don't want to stand here and
If they're under 17 or you don't.
And Judge, I understand what the court's asking, and I'm
The court That's your argument. If there's more there with regard to bias and prejudice against Mr. Walsh, I think you need to make that argument. I think the law requires you to make that argument to get the Rule 17 subpoena. It has to be something more than just generalized.
I guess, Judge, what I'm confused about, and I'm confused maybe of my own making, but let me just put it this way. It seems to me what the court is saying is that when you have distinctive evidence of bias against at least one defendant in the proximate time in the investigation of a homicide case, at least it was charged as second degree in Reed case, and you have specific evidence of a trooper and other troopers acting with bias and being salacious remarks about a defendant in a case that somehow
In the case, yeah.
that somehow and then they become aware, or they are disciplined, perhaps by, as Tully said at some point when he was told about these disparaging, biased statements, I think his response was, well, I told Proctor I wasn't happy about it. And that's about the end of it. The point is people become aware that people, being Proctor, become aware of their conduct now is being exposed, and that maybe they don't make the same type and quality of biased statements against Mr. Walsh as they did with Reed, but the fact is that the trier of fact should be able to hear specific evidence of the bias that they had close in time to another defendant, at least in one instance. Understanding it, that when you have of bias toward a defendant in a homicide case close in time, that has no bearing on that same officer's bias in investigating another person.
I'm not saying it has no bearing. I'm saying that's not enough to meet out your burden of proof under Weyness. And that's what I'm saying.
And that's where we...
I'm not disregarding it.
That's where we...
And that's why I started this hearing probably close to an hour ago saying
which was over 2 months before the disappearance and alleged homicide of Anna Walsh. So we don't have more than that. We know that the district attorney's office knew about the federal investigation because of correspondence between District Attorney Morrissey and the United States Attorney's Office.
and when does that happen?
That happens in November of 2022. We know that Trooper Proctor testifies in front of the grand jury in February of 2024, which is just maybe 2 weeks after he's assigned.
2024 or 2023? You said 2024. I think you mean 2023.
2023.
Yep.
Which is not even maybe 2 weeks before he's assigned as case manager. I apologize. I didn't have this out for Mr. Tipton. So we don't have more information than that. But to say that, how do we show that the fact that he had an open federal grand jury investigation to the way he conducts his business in a homicide investigation in the same county, and then within weeks he's involved in another homicide investigation, the bias is clear. And it's unique and apart from other cases. It's not a knee-jerk reaction that, well, Proctor, now we get his information anytime he's a case manager. He is under scrutiny. And so the argument can clearly be made, and I think there's a good faith basis. There's no additional standard. This is Commonwealth versus Fuller that's been around forever. So it's about relevance and a good faith basis. He had to show that he's a good cop, does a good job, follows all the rules, and doesn't mess around. That's the bias. It's no different than the argument we made at the last time, that if someone has an open criminal matter and they're a witness in a case, we're allowed to cross on that and elicit that in front of the jury to show they have a bias and motive to cooperate. And we don't ever have to offer more than that because it's implicit. So when you talk about have we met our burden, that is our argument that we're articulating to the court. And that was contained in the pleadings from last time.
All right, I'm not sure that's the case, but I'll go back and look at those for those dates and that information. On your representation, I certainly will.
It's in the papers from last time that you ruled on, Your Honor.
On the December hearing that I ruled on, the omnibus order?
It outlines the dates and the timeline, which is why we were initially requesting the federal materials.
Any word on that?
You denied it, Your Honor.
No, I know I denied it. No, any word from the feds?
We each filed 2 requests. I have not heard back yet. I doubt the government has either.
Not yet, Your Honor.
All right. All right. I think we were, when we exited stage left, just to redirect, you were going through 3 through 14, and the question that I had asked, again, was what specific information in the requested records, those 3 through 14, do you reasonably believe is relevant and material to this case? And I think you worked through 3 through 5. Let me get back to that pleading. Another argument coming.
Let me just address that. And
Okay.
That
DeChico, Kutkowski, and Moore. He says there are none. You want to pursue those?
I do only because I think there's a representative here, legal counsel for Mass State Police, who has agreed, and I don't want to misrepresent anything, but has agreed to look into whether there was an investigation of those 3 officers, and then we'll report back to either the Commonwealth or us or both, and then we'll move on, we'll move forward. But it could very well be that there is absolutely nothing out there.
All right, well, we don't need to, we got plenty of other things to chew on, so to speak. So if there's nothing out there, it would assist us greatly in narrowing the issues.
So I think it was represented that legal counsel for Mass State Police, if I have that right,
Is that right?
Yes, Your Honor.
Is going to make an inquiry and get back to us.
All right.
Sustaining findings against those 3 individuals, and we'll find out if there was ever an investigation into those 3 individuals.
All right. What do you think of, so 9 and 10, the Commonwealth says, well, what do you, I'll let you answer that question, then I'll, as to 9 and 10.
Those are going to be, those consist of what apparently will be specific statements of reports that have been produced is these are the statements of the supervising officer relevant to who he's evaluating. And so those are the statements that would be used to impeach. If, for instance, what we do know is Tully apparently says Proctor did an outstanding job, the highest level, when in fact he knew that Proctor was biased and was making biased and inherently prejudicial statements. And when you ignore or you try to hide the fact that your fellow Mass State Police officers are showing bias, and nonetheless you give them an outstanding rating, that goes to the integrity of, their willingness to not admit their own bias. And those evaluation and those statements in those evaluations are the actual statements of the witnesses. I don't know if those will contain specific statements, for instance, of Proctor. I know they will contain specific statements of Tully.
So with regard to that, then the Commonwealth is saying also that you're asking for everything completed by detective lieutenant without any restriction on date.
No, I don't, well, one, we're not asking for that. We were only asking for those printouts. I mean, we limit it right in the paragraph concerning the evaluation of Trooper Michael Proctor.
So do you agree that the request that you're making is only with regard to the 5/10/24 evaluation
Yes.
of Trooper Proctor?
Well, yes.
That was the subject of Detective Tully's investigation,
Yes.
internal affairs investigation. Okay. All right, and as to 10, also, do you agree that this is as to the 5/6/24 evaluation of Trooper Buchanan? I don't know if I'm pronouncing his name correctly. That was the subject of Tully's internal affairs investigation.
Well, if you're referring to paragraph 11,
No,
which paragraph are you referring to?
10, unless I've got it wrong.
No, just a minute. I'm looking at ours.
I think she means 11.
Commonwealth,
Your Honor, I see them as the same. I think defense is asking for the
are
same.
they two different dates? That is, I read from what you, your opposition, that the 5/10/24 evaluation of Trooper Proctor is different than the 5/6/24 evaluation of Trooper Buchanan,
I,
and that the investigation as to Detective Lieutenant Tully was his handling of those two separate evaluations that were done on different dates.
and I just,
Close, but different dates.
and I don't know because I don't have those evaluations. So,
I don't either. I'm just going off of what's in your opposition.
yes, Your Honor. And so, in the abundance of caution, there could be two evaluations, but I read it as one with two different dates on it.
I'm not sure I understand, but maybe you can sort that out for me.
So I guess, Your Honor, what it is that Detective Lieutenant Tully reviewed Sergeant Buchanan's
Evaluation.
evaluation. They're done on different dates.
Right, that's what I just said.
I apologize.
No, that's how I read your opposition, that there are two, they each have their own separate evaluation. They're probably done on the same cycle, a May cycle. One of them was dated 5/6/24, the other one was dated 5/10/24. And the alleged wrongdoing of Detective Lieutenant Tully was that he didn't bring to light this information that he then knew about, right?
Yes, Your Honor.
All right. And it was substantiated that that was, in fact, wrongdoing, correct?
He was sustained, those findings were sustained, Your Honor. Yes.
Right, I got the wrong word, substantiated, sustained.
Yes, Your Honor.
All right, now we're at 11.
And I believe it's and what I limit that to is where performance ratings were subsequently determined to be inaccurate. I'm not asking for the world here. We're not asking for every single document. We're asking specifically for when a rating was made in the past that has not been produced, but the Mass State Police know that it was an inaccurate rating based on some other conduct. Why aren't we entitled to that?
So let me just say this. I assume, I don't know what the rules are, but I suspect that they probably get evaluated annually. And so somebody correct me if I'm wrong. They haven't, I don't know.
No,
All
you're
right, let me presume for this discussion that they get evaluated annually. And these text messages, or that's probably what the reg says, if they really get done annually, I don't know. I spent a long time, well, enough time in the military to know on these annual schedules that they're a little loose on that. But maybe the Mass State Police is a little tighter than the Air Force. In any event, are you looking for, so he may have been evaluated between the time that he made the inappropriate text messages and the time that his supervisors knew of the inappropriate text messages, which I think you just told me was sometime in February 1st, 2024.
Yes.
So under one reading of the word inaccurate, the 2023 evaluation would be included as inaccurate. And under another reading of the word inaccurate, it would not. That is, it wouldn't be until Detective Lieutenant, or maybe Buchanan too, because he was evaluating
Is.
I'm trying to.
Can I just ask something? My memory is when I was reading through all of this that there is the reference to quarterly evaluations under this system. So, you know, it's not just yearly, it's quarterly.
All right. So the same question. I'll take your representation that it's quarterly. So are you? What the Commonwealth said in its opposition is, well, they didn't agree with you that they were inaccurate. I guess, is that right?
Forgive me, Your Honor, I got my coat caught. We thought it was overly broad because it's asking for any evaluation and where there could be an accurate reading. And so any is overly broad in this case.
Mm-hmm.
And I just want to add something here, because the court is rightly looking at Waynes. We don't disagree with that, but we disagree with the way the court's interpreting. But the point is this: Waynes's underpinnings. The SJC made it clear that what they were trying to protect was, I think they referred to as the morale of the police. They don't want people always being able to say, let's get all the internal affairs and all the complaints made against an officer, and how that will affect the morale of the police and the way that the police interact with the prosecuting attorney. And maybe I've read too much into that. And then there's a second policy reason for Waynes that justified the SJC justified what they were doing, was that they wanted to make sure that people who reported crime knew that their identities may very well be protected and not just the subject of, defense attorneys like me saying I want everything about everybody in a case. Well,
Agree.
Let's just look at what this case is about then. And the reason and the reason why we file this motion, it's because in this case we have specific evidence of bias that I'm not going to repeat. Yes, it's in a different case, but we've already argued all that. Yes, it's in a different case. And then we have a group of Mass State Police that are involved in the investigation of Walshe, and they're trying to cover up or hide their colleagues' misconduct and their bias until they're all called on the carpet. And so when you see that Tully is called on the carpet for making an inaccurate assessment of Proctor, a trier of fact then, if they heard specific evidence of that, even if it was in a different case, because now, and I'll use the phrase, now the troopers have cleaned up their act and they know that text messages might be discoverable. Well, now all you have is to tell the jury, this is the way they conducted themselves until they got caught. And they were under the microscope when they were investigating Mr. Walshe. And that's why this case and these requests stand in a different light than some broad request where we don't have what we already have. And frankly, Judge, I don't know that if, I really don't know. if some supervisor, Mass State Police like Tully, evaluates Proctor and calls him out, labels him outstanding, when in fact they're aware of other misconduct, I don't know what the Mass State Police does with that. But it's still evidence of distinct bias in the way that they when it comes to impeachment, that is the best evidence. And I also would add, and I wish I had the name of the case with me, but even though the government has chosen not to call Proctor in this case, and I don't care about other cases, I'm talking about this case, the case law is clear that you can still impeach a non-testifying witness as if he was on the stand. Certain statements or certain conduct that that witness has done is suitable for being impeached. He doesn't have to be on the stand, or she doesn't have to be on the stand. And so what we're looking for in 12 and 13 are the actual statements that were made by the people during this investigation. And I presume they were made under oath. As for 14, I'll just end on this. We keep asking for this, and we keep being told we're not going to get it unless we get it from the feds, and we've asked for it.
All right, thank you. Do you want to respond to any of those 3 through 14?
I will try, and I will also try to be brief. First, I would like to just let the court know it is my understanding of the timing of all of this that these officers, that Trooper Proctor didn't know about a grand jury investigation, or the state or law enforcement didn't know about a grand jury investigation until May of 2023, when it was announced in open court by defense counsel in the Karen Reed matter.
So this timeline that was given, that that it was known that the DOJ investigation began in 11 of 2022.
I believe the investigation started then, Your Honor, but it wasn't.
But it wasn't known. Well, certainly, I would think not. But if of
Your Honor, we don't agree unless there's something that hasn't been provided, that the Mass State Police, specifically Trooper Proctor, did not know there was a federal investigation opened in November. All we have been provided is that the federal investigation commenced in November of 2022, that the Norfolk County District Attorney's Office knew about the investigation.
When?
In November of 2022.
What's the evidence of that?
There's correspondence between the District Attorney Morrissey and his first assistant, between them and then first assistant
Josh Levy?
Josh Levy. But what we don't know is the exact moment of when Trooper Proctor became aware, unless the government can point us to a piece of paper that shows he didn't know until a certain point. We do know that he testified in February, so that is very close. So we don't know when he got the summons, when he was contacted. If that exists, we'd love to have it, but right now, I don't know how we can say for sure he didn't know.
Your Honor, he has never received a target warning, nor has anyone from the state police has made it discoverable to us that they've received a target warning, which we would want to know if they were the subject of a grand jury investigation. There was communication between the two offices. It was my understanding in May of 2023, summonses went out to civilian witnesses to testify at a federal grand jury, and that was made public in court. And that is when they knew about that's when this office and the state police understood people were testifying at a grand jury investigation.
Again, but it's a grand jury investigation into the death of John O'Keefe?
Yes, Your Honor. Your Honor, a little more context, and the Commonwealth can correct me if I'm wrong. The tenor of the correspondence between the Norfolk County District Attorney's Office and the United States Attorney's Office was the displeasure by the Norfolk District does add some context. The court is thinking about the timeline of who knew what when.
So, but contemporaneous with the opening of the federal investigation in November of 22, all parties agree, based on what you've reviewed, that there was correspondence at that time.
Remember, at the last date, I never agreed that we knew that the district attorney's office knew the state police was under.
I know this came up with regard to the discussion of whether they were working collaboratively or not.
And I think the tenor of the letters would suggest they're not. And I think that there is we would have preferred to see, actually, I think the letters will speak for themselves. And I'm happy to submit them to the court. We've turned them over in discovery. They've been the subject of public records requests. They exist. That being said, Your Honor, my understanding is the state police did not know people were testifying at a grand jury until May of 2023. In addition, Trooper Proctor did not testify until February 2024, and he never received a target letter. To my understanding, he's never received target warnings ever. And my understanding also is this has continually been an investigation into the death of John O'Keefe.
If I may.
Give me 1 second, and sure. Yes, counsel.
Commonwealth represents it's an understanding that was an investigation into the death of John O'Keefe that revealed the bias of the Mass State Police.
I think that was produced at trial in the Karen Reed matter. I don't know if that was the subject of the investigation, but the text messages were provided at trial, and they were read into the record. It's also my understanding no one has been charged with this grand jury investigation. And I have yet to been notified of anyone, civilian or law enforcement, receiving any target warrants. For the potential